Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to go back now and talk about a very disturbing case. We call it a very disturbing case because at one time we called it the worst Second Amendment ruling that we had ever read. And we called it that because, in fact, it was the worst Second Amendment ruling we'd ever read. The losing party now has decided to petition to the United States Supreme Court to determine which one of these actually reigns supreme, the Second Amendment or the Aloha Spirit. Well, there's an amicus brief that I think does an excellent job of just summing up what this case is truly all about. And so we're going to spend a few minutes today and we're going to geek out on that. So today, let's spend a few minutes and let's talk about the effort to overturn the worst Second Amendment ruling ever. Okay, we are talking about the case of Wilson v. Hawaii, formerly known as Hawaii v. Wilson, formerly known as the Aloha Spirit case, formerly known as the absolute most atrocious, most steamy pile of crap of a judicial opinion ever authored, brought to you by the Hawaii State Supreme Court. Now, this amicus brief, which we're going to be going through today, is brought to us by our good friends at the Second Amendment Foundation, which means if you guys want to show them some love, we will have links down in the description box for that. Okay, listen, we're not going to get too deep into the woods and get into all the gore of the previous ruling. You can check out that video right there if you need to get up to speed on it. But essentially, the Hawaii State Supreme Court found that the Second Amendment does not protect the right to carry a firearm outside the home. And you sit there and go, well, yes, it does. And of course it does. Okay. And that is one of the many, many reasons why this is in fact the most terrible ruling in the history of Second Amendment rulings. Now, Wilson, of course, has now appealed to the United States Supreme Court. And I should point out that unlike the Maryland assault weapon ban case, which has now already been sent back down, and all of the Illinois assault weapon ban cases, which really there is still some final stages to take place. This case, it can't go any further. It's been appealed to the Hawaii State Supreme Court, and the Hawaii State Supreme Court has come up with this amazing ruling, comical ruling, if you would, and in many ways the way they thumbed their nose at the United States Supreme Court, that should be reason alone for the Supreme Court to take this case. Now, I always love the way a party just sums it up right away and kind of their issues presented. You know, you never get a second chance to make a first impression. And the Second Amendment Foundation basically points out that this case is about this. Although Hawaii is geographically separate from the rest of the nation, the United States Constitution and its court's rulings apply with equal force as in any other part of the country. Yet on February 7, 2024, the Supreme Court of Hawaii brazenly defied this court and held that in Hawaii there is no constitutional right to carry a firearm in public for possible self-defense. Now, this case, in large part, comes down to something that we have not had the opportunity to geek out a lot here at Washington Gun Law, which is the Supremacy Clause. The Supremacy Clause is found in Article 4, Paragraph 2 of the United States Constitution. It essentially says that, listen, federal law will always trump state law. Federal court precedent will always trump state court precedent. And as the Second Amendment Foundation points out here, the Supremacy Clause of the U.S. Constitution forbids states from violating the minimum standards of the Constitution and federal law. To that end, this court has made clear that its interpretation of fundamental rights provided a floor of minimum constitutional protections. States are free to adopt more expansive interpretations of rights where authorized by state constitutions, but they may not use state constitutions to diminish rights provided by the U.S. Constitution. So essentially, every single state must guarantee the same rights that are guaranteed under the United States Constitution. And a state, if they so desire, could actually guarantee their citizens more rights. I'll give you an example. Article 1, Section 7 of the Washington State Constitution clearly provides far more protection from unreasonable searches and seizures than its federal counterpart found in the Fourth Amendment. There is a litany of case law in my home state of Washington to suggest that. So yes, they can advance more rights, but they can never get below that minimum baseline. So then, how does that comport with the Aloha Spirit? The Aloha Spirit does not trump the Constitution of these United States. This court should send a message to lower courts who defy its commands and summarily reverse. Listen, we already have very clear Supreme Court precedent, District of Columbia v. Heller, that the Second Amendment does extend to the right to carry a firearm outside the home for lawful purposes, including self-protection and self-defense. As the Second Amendment Foundation points out here, hey, Hawaii, you're stuck with that ruling. We don't care what you think. Thus, it is well settled that the U.S. Constitution sets a floor for the protection of individual rights. As discussed below, state Supreme Courts have adhered to this maxim. Hawaii's current court, however, has chosen to ignore this well-established principle. And one of the big reasons that the United States Supreme Court needs to accept this case is not only to protect the obvious rights that are being infringed of the citizens of Hawaii, but it's to rein in all these renegade courts that are essentially committing mutiny upon the United States Supreme Court. As SAF points out, other state Supreme Courts have long acknowledged that under the Supremacy Clause, this court's decisions control in matters relating to the U.S. Constitution. They have also respected their duty to stay above the constitutional minimum requirements set by this court. Yet in the case below, Hawaii's court went rogue and disregarded the Supremacy Clause. But the Supremacy Clause is a basic principle of federalism under which there is no room for a state Supreme Court to push a radical social agenda and dare this court to grant certiorari and summarily reverse. So had Hawaii chosen to interpret an individual's Second Amendment rights in a manner that was far more expansive, thus providing more protections than what current federal case law or what the United States Constitution requires, there is no problem with that. But you see, Hawaii, yeah, they chose to go the other way, and it is a door that only swings one way. In summary, while expansion of constitutional rights may occur at the state level, contraction of rights is verboten. The Supremacy Clause makes the U.S. Constitution, as interpreted by this court, the minimum standard which all states must enforce. This is a non-negotiable matter of federalism. The Hawaii court had an obligation to maintain the floor of the right to carry a firearm in public for self-defense in the state of Hawaii. Instead, the Hawaii court chose a very different path in a fit of intemperament anti-gun judicial activism, choosing to ignore the minimum Second Amendment protections announced by this court. And listen, although we have seen many states essentially throw middle fingers at the United States Supreme Court, take for example New York's Concealed Carry Improvement Act, take a look at Illinois' Protect Illinois Community Act, take a look at California Senate Bill 2. But as SAF correctly points out, yeah, no, Hawaii, they've taken it to another level. While a minority of states remain hostile to public carry and impose draconian permitting restrictions on peaceable, law-abiding adults, Hawaii now stands alone in failing to recognize the constitutionally protected right to carry firearms in public whatsoever. Okay, the case once again is called Wilson v. Hawaii. The memorandum, the Amicus memorandum that we talked about today, once again is brought to you by the good folks at the Second Amendment Foundation. We will link them up below. We will link the memorandum up below so that you can geek out on it for yourself. Maybe you guys got ideas for videos that we should be doing here at Washington Gun Law. If you do, go ahead and click on that link right there. Some of the best ideas we ever had, candidly, weren't our ideas to begin with. Maybe you got more questions about this or something else related to what's left of our Second Amendment rights. If you guys do, all of Washington Gun Law's contact information is right down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.